Welcome to The Explainer. If you're a law student burning the midnight oil right now, or maybe a neophyte lawyer getting ready to advise your very first corporate client, you are in exactly the right place. Today, we're putting Republic Act 10173, which you probably know better as the Data Privacy Act of 2012, under the microscope. We're going to treat this explainer like a masterclass. We'll give you the absolute essential tools to navigate this critical piece of legislation, all the way from boardroom compliance right down to courtroom litigation. So let's just dive right in.
To really grasp the mechanics of any law, you first have to understand its spirit. Section 2 of the Act, which is the Declaration of Policy, actually has this incredible, inherent tension built right into the text. On one hand, the state is strictly mandated to protect the fundamental human right of privacy, but in the exact same breath, it has to ensure the free flow of information to promote innovation and economic growth. It's a massive balancing act. And as legal practitioners, your entire job is going to revolve around managing this exact tension for your clients. All right, here is our doctrinal roadmap for today. We're going to cover scope and key definitions, principles of lawful processing, rights of data subjects, security and accountability, and finally, penalties and liabilities. Let's start right off with Section 1, scope and key definitions. Okay, so before you can advise a client, you have to know who the legal actors actually are. The law makes a really critical doctrinal distinction between a controller and a processor. The Personal Information Controller, or PIC, is the entity that actually decides what information is collected and why. They are essentially in the driver's seat. The Personal Information Processor, or PIP, is just an outsourced entity that simply follows the controller's instructions. Why does this matter to you as a lawyer? Because this distinction completely dictates who bears ultimate legal liability if things go terribly wrong. Next up, we really need to establish the legal baseline. What data does this statute actually protect? Well, Section 3 defines personal information as any information from which the identity of an individual is apparent or can be reasonably and directly ascertained. So think about it. It's not just a name or a clear photo of a face. If an entity holds a piece of data that, when pieced together with other information, would directly and certainly identify someone, that is legally recognized as personal information, and it's protected under this act. It's kind of like a giant puzzle. But the law also recognizes that not all data is created equal, right? Enter sensitive personal information. Now we're talking about things like race, marital status, health and genetic data, social security numbers, tax returns, and even classified government info. If your client is, say, a medical clinic, an insurance agency, or a government contractor, their legal baseline completely shifts. The law treats these specific categories with way stricter standards, and processing them is generally totally prohibited unless you meet some very strict statutory exceptions. Moving right along to Section 2, Principles of Lawful Processing. Shifting gears into the compliance side of the law, any legal data processing operation has to be built on 3 foundational principles from Section 11. First is transparency. The data subject has to know exactly what is happening with their data. No secrets. Second, legitimate purpose. Whatever you're doing with the data must be compatible with a specified, declared purpose that isn't contrary to law or public policy. And third, proportionality. The processing has to be adequate, relevant, and definitely not excessive for that declared purpose. You literally can't ask for a customer's blood type just to sell them a pair of shoes, right? It's simply not proportional. And if we look at Rule 4 of the Implementing Rules and Regulations, the IRR, it breaks down how these principles apply in the real world. Collection has to be specified and legitimate. And crucially, you need time-bound consent. The data has to be processed fairly and lawfully, ensuring data quality. And here's a big one. Personal data cannot be retained longer than necessary. Once the purpose is achieved, your client cannot legally just hoard that data forever just in case it becomes useful later on. Let's flip the script and look at Section 3, Rights of Data Subjects. So we're shifting from corporate obligations over to civil rights. As a neophyte lawyer, you aren't always going to be representing the big corporation. Sometimes you're going to represent the aggrieved individual. So you have to ask yourself, what can your everyday individual clients legally demand from these powerful entities? While Section 16 and Rule 8 give them a seriously comprehensive toolkit of 8 specific rights. Your client has the right to be informed that their data is being processed in the first place. They have the absolute right to object to it. They can demand access to their data. They have the right to correct inaccuracies, and the incredibly powerful right to rectification, erasure, or just blocking their data entirely. If their rights are violated, they have the right to claim damages. Also, these rights are transmissible to heirs. And finally, they have the right to data portability, meaning they can demand their data back in a structured, commonly used electronic format. When you look at the specific legal mechanics here, you really see how powerful these rights are in practice. Under the right to correct, the data subject can dispute an inaccuracy, and the controller has to fix it immediately, unless the request is obviously vexatious. And under the right to object, individuals can outright withhold consent to processing if there are changes to the information that was initially declared to them. Honestly, this is the exact legal ammunition you'll be using when your client's data is mishandled. Next up, Section 4, Security and Accountability.
So the law doesn't just casually say, hey, don't misuse data. It actually places strict, affirmative legal duties on entities to actively defend the data they hold. Rule V mandates 4 main pillars of security. First, organizational safeguards. Think employee training and airtight confidentiality agreements. Second, physical security, actually locking the filing cabinets and restricting building access. Third, technical or cybersecurity measures to stop digital breaches. And, importantly, they absolutely must designate an accountable individual, which is widely known as a data protection officer, or DPO. Your corporate clients need all this in place, for sure.
And that leads us to a very common trap. Rule 12 of the IIR explicitly states that a controller is responsible for data, including information that gets transferred to a processor. Let me put that in simple terms. Your client can outsource the IT work all they want, but they absolutely cannot outsource the legal liability. The controller remains on the hook. Which brings us to our final and most critical part, Section 5, Penalties and Legal Liabilities. When we're talking about risk management, this is the hammer of the Data Privacy Act. Advising clients incorrectly here carries some incredibly grave consequences. Just look at this. Unauthorized processing of standard personal info, that can result in 1 to 3 years of imprisonment. But look what happens when it's sensitive personal information. The prison term jumps to 3 to 6 years, and the fine literally doubles. And what if a company suffers a security breach and intentionally tries to sweep it under the rug? That carries up to 5 years behind bars. These are not just slaps on the wrist. We are talking about serious criminal liabilities. And really, let this number sink in. 4 million pesos. That is the maximum statutory fine for the unauthorized processing of sensitive personal information. And here's the kicker. That is per violation. So if a company is mishandling thousands of patient records or employee files, the financial risk is just massive. It's potentially ruinous. And for all the junior lawyers out there, here is the stark warning you absolutely must deliver to your corporate clients. Under the penal provisions of the Act and the IRR, if the offender is a corporation, the penalty of imprisonment isn't just some theoretical threat. The law specifically says that the penalty shall be imposed upon the responsible officers who participated in or, by their gross negligence, allowed the commission of the crime. So no, the corporate veil is not going to protect a negligent CEO or a careless IT director from facing actual prison time under this act. And wow, that really brings us full circle, doesn't it? As you step out to practice, your job is going to be supporting that vital role of technology while fiercely defending the human right to privacy. But I want to leave you with a question to really think about. As artificial intelligence and big data just keep evolving at lightning speed, is the Data Privacy Act of 2012 truly equipped to protect us, or is the concept of absolute privacy already obsolete? Something to chew on. Thank you so much for joining me for this explainer. See you next time.